Hi, everyone. Welcome to today's webinar on California employment law updates for 2018. I think we're going to probably have some people trickling in a few minutes late, but I'm going to get started anyway because it's time. So for those of you who don't know me, my name is Galia Aharoni. I am the founding partner of Aharoni Business Law, a law firm based in the San Francisco Bay Area, but we represent people throughout California and actually some international clients as well, everything to do with California law. What we do basically at Aharoni Business Law is what we call outside in-house counsel. So kind of general counsel issues that pop up for all businesses, from starting a company, helping them figure out what type of entity they should be, contracts, employment law, and intellectual property, including trademarks. So today we're going to be talking about the employment law changes that happened and that are happening starting in 2018. This is, to be honest, it's actually one of the more boring of the programs that we end up doing throughout the year. We do programs at least once a month, but we do it every single year in January or February because it's really, really important. Not only for employers, but also for employees. So as an employer, it's really important to know what the laws are, and they're constantly changing, to make sure that you individually are protected, your assets are protected, and your businesses are protected from potential liability. It's also important for employees, though, because I think even though I represent employers and not usually employees, it's really important that everybody knows what their rights are, to make sure that they're being protected from employers who are trying to take advantage of them. But in my experience, I've found that the vast majority of employers are really just trying to do the right thing and take care of the people, take care of their businesses. What gets people in trouble, employers in trouble, is actually most of the time just totally by accident, infringing on a law that they may not have even known was there. And so that's why we do this program every single year. It's a really important one to make sure that you know what the laws are and what you need to be doing to protect yourself going forward. So that's the context here. The laws are constantly changing, like I said. Basically, every single January and every single June, there are new laws coming out, and it's a minefield for employers because there's federal laws constantly changing, there's state laws changing, and there's local laws changing all of the time, and you need to be aware of what all the different laws are and how they relate to each other. So most of the changes happen in January, some happen in June, but we also get some that happen in weird months too, like September or something. So it's really important to constantly have your pulse on what's going on in employment law if you have employees or if you are an employee, and have some sort of proactive way to get that information, whether it's coming from us or another lawyer or a blog or something. Some way to find the information, but at least at the very minimum, we recommend looking it up every January, every June, make sure you're being compliant. So another thing to keep in mind here that we'll check in about is that occasionally there are some laws that apply only to employers with a certain number of employees. So it's really easy to, be going along doing your business year after year, not thinking that a certain law applied to you, and then you hire somebody and you hit 25 employees or 26 employees or 5 employees or whatever the threshold is for some certain law, and suddenly a law applies to you that you didn't know, that didn't apply to you before, and you don't think about it. So it's easy to accidentally break a lot of these laws, which is why we're going to be talking about a lot of them today. So before we jump in, I do want to point out that there is an opportunity to ask questions of me. So the way we're going to do that is take a look and try and find the chat box right now. I did send a chat to everybody to show that that's where the questions should be coming in, but you can type a question into the chat box. It'll come just to me, and I'll try to answer some of them as they come up, but hopefully there'll be time at the end for questions as well. But if I don't get to your question for whatever reason, you feel free to email me anytime and ask the question, and we can share the slides with you, or we can answer your question individually, or we can set up a phone call, whatever is the best. And so hopefully we will get all of your questions answered today. So before we jump in, I did want to say that we are going to be kind of skimming over the minute details of all of these different ones, first of all, to try and make it a little more interesting, but also the main goal of this for me is that you just know that the law exists, you know whether it applies to you, and then at that point you can look it up or you can get in touch with an expert to figure out how to go from there. But I don't want everybody to get bogged down in just the small details. Because it's overwhelming. So I just want you to know enough to know whether it applies to you. So from there, let's jump right in with the very first one. This is probably one that hopefully every employer in California is aware of already. There is a minimum wage increase that kicks in January. For employers with 26 or more employees, it's now $11 an hour minimum wage. In California, and if there's 25 or fewer employees, it's still $10.50 an hour. So this minimum wage is going to be going up and up and up every single year until 2023 throughout California. But do keep in mind that other cities throughout California have their own minimum wage going on right now that's even higher than the state minimum. So here's a list of the increases that have happened on a citywide basis throughout the state in January. So if your city is one of those, make sure to check to see what your individual minimum wage is right now. But also there are other cities that are above the state minimum right now that just haven't done an increase in January. So make sure if you're an employer, just check to make sure what your local city minimum wages, make sure you're complying with that. But generally, it's going up for everybody throughout the state of California. That also means that because there's a new minimum wage, there's also a new minimum wage poster that is required to be posted in your office right now in a place where your employees can easily see it. So hopefully everybody's posters are up to date, but if you haven't updated them in a while, this is one of them that has changed in January and will obviously change every January for at least the next few years. So make sure that is also updated. There are some also minimum salary increases. So even if you have some employees who are not being paid hourly, they're being paid a salary instead, there's still requirements in the state of California about minimum salary you're allowed to give these exempt employees. So there's a bunch of different categories and they each have, some of them have their own minimum salary requirements. So the only one I'm going to mention is the executive and administrative and professional exemption. The minimum per year for a full-time salaried employee who falls into that exemption is now at $45,760 a year for employers with 26 or more employees, or $43,680 if you have less than that. So again, make sure that this is a one thing that's easy to accidentally do. Not realize that, people think that if I have somebody on salary, I can pick whatever salary that we agree on, but there actually are minimums for requirements for a lot of these. So I just wanted to mention this minimum wage increase because, again, it's one of these things that's kind of easy to accidentally mess up. January happens, it automatically goes up, we forget to reflect it on payroll, and suddenly somebody's suing us and we have to spend tens of thousands of dollars trying to work it out, or we're paying penalties if somebody, called the labor board or something like that. So just to make sure that you have your pulse on your local minimum wage. All right, so the next one I wanted to talk about, that some of you might have heard about already, is the New Parent Leave Act. So this law only applies to California employers who have 20 or more employees. And so what this is going to require of us is that these employers with 20 or more employees now are required to provide new parents up to 12 work weeks of unpaid but job-protected leave to bond with their new child. So this applies to a new baby of their own, but also to adopting a baby or fostering a child in their home. It's only required for bonding with the child. It's not you're not required to give this to them for other reasons like family members, medical issue, or anything like that. It's just for family bonding. But they have to take it within 1 year. The employer is required to keep their job open for them or a similar job open for them. And you do have to continue to maintain and pay for their health insurance coverage if it's something that you're providing in a group health plan already. That's your obligations. One way that it's accidentally easy to mess this up is that as far as the job protection goes, you're required to give them a guarantee of their job before they leave on this leave. So you have to guarantee restatement to the same or a comparable position. If you don't guarantee that to them before they leave, that's a violation. So that's just one of those small things that is easy to accidentally mess up because, it's left unsaid, or, sure, we'll give you, it has to be explicit. You have to have that conversation before they go out on leave. So be careful there. And again, the other way to accidentally forget about this one is if you've had 19 employees for ages and suddenly you add one more and you have 20, and excuse me, suddenly this leave applies and it didn't have to apply before. So beware. All right, so the next one here, this is probably the one that's been talked about the most in the media lately. It's called the ban the box provision, is the kind of the slang for it. So this applies to employers in California with 5 or more employees, so pretty small companies. This means that you are not allowed to ask about criminal history on job application. You're not allowed to ask for or consider any criminal history at all before you give them an offer of employment. So this is a pretty big deal and a pretty big change. They call it ban the box because it's sort of referring to that little check mark box on a lot of the like kind of standard applications that says like, have you ever been convicted of a felony? And they check yes or no. So this is the box that they're trying to ban. So there are some exceptions, but they are pretty limited exceptions. So it's for positions where, for example, where the criminal background check is required by federal, state, or local law. So this is this is a big change to how things have been before. So you're not allowed to ask or inquire before the offer. So what happens when you do give them an offer and then you want to run the background check? There is now rules about how you're allowed to do this as well. So the first thing you need to do is conduct an individualized assessment of the person and the job. So you're going to run the background check, or you're going to ask them about their criminal history, and you have to do a person-to-person analysis about whether that conviction has a direct and adverse relationship to the job's specific duties that justifies denying them employment. So basically, we're going to be looking at what the exact duties of the job are versus what the criminal history was, and they have to be directly related for it to be a reason to not give them the job. So for example, if somebody got a bunch of DUIs, that's probably going to be directly relevant for if they're going to be driving a delivery vehicle for you, for example. But it might not be so relevant if they're just a cashier or a stock person in the store. So that would be an example of directly related. Another one is, if they got convicted for cutting fraudulent checks. You're not going to. That's going to be directly related to a job in a bookkeeping firm or something where they're handling client checks or they're handling your money, but it's not going to be super relevant if they're stocking shelves. So you can't just refuse to hire them unless it's directly related to the job. So the next one is, after you do this individualized assessment, we now have to give them written notice and give them an opportunity to respond. So you have to, there's a specific timeline on this that the process is detailed, and you have to follow the new law of this process. But basically you are legally required to consider any information that they are giving to you before you make your final decision. So even if you find that you think that their criminal history is related to the job, and you give them written notice saying, hey, I don't think I can hire you because of this, you need to allow them to respond to you and explain to you, hey, maybe it was a drug conviction and they're working in as a cashier in the pharmacy, but maybe they've been in rehab for a really long time, and they have proof that they no longer, things like that. You have to give them the opportunity to respond. You have to take that into consideration and reanalyze the situation based on what they said. So after that, you're then required to give them a final decision in writing. So this is another specific written notice to the person about the final decision to not hire them because of it. So if you violate any of these steps, this person can sue you under the California Fair Employment and Housing Act, or FEHA. So this will be a really interesting one to watch how it plays out, because A lot of it is kind of subjective. It's forcing you to go through this process, but there isn't a lot of guidelines yet about how closely related to the job it has to be, it's going to be really hard, I think, for employers to prove that you took their opportunity to respond into consideration. So I think there's going to be a little bit of time trying to figure out the parameters of this law, but the main thing for employers to know really is don't ask about their criminal history before you give them an offer, and after the offer, if they do have a criminal history you find out about, it has to be related, and that there is a really specific process you have to go through. So just beware if that comes up, and do some research or contact a lawyer to talk about that. All right, so the next one. This is also another one you may have heard of in the news lately. Every employer in California is no longer allowed to ask about an applicant's prior salary history. So you're not allowed to, usually how it goes, you have the interview with somebody, it's going well, you ask them what they made before, so you can give them a number. But the state felt that was contributing to a lot of income disparity and possible discrimination. So now they're not letting you ask that at all. You can't ask about their salary. You can't ask about any sort of compensation or benefits that they had at a previous job. And if you do know what their salary history was, you're not allowed to use it as a factor in determining whether to hire them or how much to pay them. So, say you have two applicants and one was paid a lot more than the other, you can't use that as a factor to decide which one you're going to hire. Let's see. Oh, and this includes a recruit if you're acting on behalf. If a recruiter is acting on behalf of you, you can't just say like, "Hey, recruiter, go find out how much they were making before, so I know how much to offer them." That counts. Nobody can ask about salary history anymore. So the other thing that's required of you is if the applicant asks you for a pay scale of what you're offering for the job. If it's a reasonable request, you do have to provide that to them. So you can, however, if somebody volunteers it to you, you can consider it if they volunteered it without prompting. So again, this seems like another one that's really easy to kind of mess up by accident. We're so used to asking this question. It's so easy to accidentally ask this when you're negotiating somebody's salary. And it's also going to be harder for employers to figure out what to offer and what to pay and how to negotiate a salary. So this will also be interesting as the law sort of goes on and as lawsuits start happening. But the main thing for you to know is when you're hiring somebody, just don't ask them what they were paid before or what their benefits were before. If they offer, then okay, but you can't ask anymore. So also in San Francisco specifically, you can't. If somebody asks, if a third party asks you for information about a current or former employee about their salary, you can't give that to a third party without the employee's written permission. So again, just be really careful if something happens. All right, so this is a really big one, and the Immigrant Worker Protection Act is a really big new one, and I'm actually surprised at how little coverage it's kind of getting in the news and stuff. I think a lot of people haven't even heard about this one, but I think this is going to be kind of a pretty big hotbed for potential lawsuits, and I think it's employers now are going to be walking a really, really fine line between complying with federal law and complying with state law. So this basically is in response to the federal government. They've been rating employers, a lot of places like 7-Elevens and things like that, a lot lately, arresting workers and demanding paperwork from employers about workers. And the federal government has said that they plan on continuing to do this more and more. And in fact, some of you might have been reading that they specifically said lately that they're going to be targeting Northern California because of laws like this that California is trying to enforce. So as the federal government is doing more and more of these raids, California's response was to enact this Immigrant Worker Protection Act. So what this is doing is requiring that employers cannot give federal immigration agents access to any non-public area of the company or of employee records without without a warrant or a subpoena in advance. So this is kind of a big deal. This means if there's a raid and the federal government comes in trying to look for undocumented people or people who don't have appropriate documentation, the company now it's illegal for them to give access, even voluntary access, to the federal immigration agents, other than just in the public areas, unless the immigration agents have a warrant or a subpoena in advance. So the exception to this is the I-9 inspection requirements. The way that this will go instead is the federal government is going to give the company a notice of inspection, and this is because of prior law. They'll give a notice of inspection, but then California law now says if you get a notice of inspection of these I-9 records, the employer now has to give notice to the employees within 72 hours that they did receive this notice of inspection from the federal government. And after they've granted, the immigration agents the right to inspect these I-9s, the employer now has to give a copy of that to the notice of inspection to every affected employee upon request, and they have to give the inspection results to every employee within 72 hours of receiving the results from the immigration agents. So an affected employee is any employee identified by the immigration agents as potentially lacking work authorization, or their documents were deficient in some way. So there are really specific guidelines and requirements now for the notice you have to give and the timelines you have to give and what you have to give your employees and when. And now you're sort of stuck in between not violating these state laws, because each violation of the state law can be between $2,000 and $10,000, but also making sure you're complying with all of the I-9 requirements, and because any violation of those can be anywhere from $200 to $20,000. So it's really important here if you feel like you might be at risk for this, I mean, anybody in the state of California and in the country can be at risk for a federal immigration inquiry, but it does seem like they're targeting certain industries more than others. So especially if you feel like you're in one of these industries, make sure to do a thorough training with whoever's going to be on the front lines here, whoever's in the front desk or going to be the one that they're going to be contacting. Make sure that they at least know the rule about not allowing access without a warrant or a subpoena to non-public areas. Because again, if somebody bursts in the door and they say they want access to the records and they want to look around, that's probably going to be really intimidating. And it's really easy to just say, oh, sure, you have my permission, but that's illegal now. So make sure whoever is going to be the person, on the front lines, make sure they know not to let the federal agents in without a warrant or a subpoena, and make sure that the process for giving notice to all the affected employees, all of that, is well known within the person who's going to be on the front lines person. So we do recommend that you create sort of these processes and documents in advance. So if it does ever happen, you have your whole system in place, you have all your records in place, especially because there's these 72-hour windows where you have to give the notice. So you don't want to have to get the notice and oh my God, what do I have to do again? And then you look it up and you call the lawyer and I need these documents right away. What do I do? It's a lot more peaceful, and you'll have a lot more time to prepare these processes and paperwork in advance. So you have it ready to go if this inspection ever happens. So we recommend standardizing everything. So that, again, I think will be really interesting. It places a lot of burden, I think, on California employers to kind of really walk this line between complying with federal law, but also complying with the state law, not to cooperate really to a voluntary degree. So it's really important that every employer throughout California knows about these rules, so they don't accidentally get slapped with huge penalties from either side. So that's one I wanted to make sure that you all knew about, because it's going to be a really important one over the next few years, I think. Okay, so moving on from that, looks like we don't have any questions yet, so we'll just keep going. And let's see. Okay, so California also has been really good about constantly updating their laws to adapt to a lot of the dialogue happening about gender and orientation, identity, expression, all of those things. So there's a few laws relating to them that have just come out in January. So the first one is that, in California law already requires that employers with 50 or more employees, they already are required to have sexual harassment prevention training given to all of their supervisors every 2 years, and also upon hire of every supervisor. So California has now expanded this to include training on gender identity, gender expression, and sexual orientation. So the trainings are now, by law, required to have information about that and these trainings as well. These trainings are only required for companies with 50 or more employees, but we routinely counsel a lot of our clients to put these trainings on anyway, just because it's a matter of good course to educate all of your employees, but also to protect yourself from liability. So if you are doing these, even if you have fewer than 50, we do recommend including that new information in there. So next, there's also a new poster here for employees that have 5 or more employees that covers the rights of transgender workers in the workplace. So make sure you have one of those if you have 5 or more employees with the rest of your posters. There's a new gender identification law in California now that allows California residents to now choose on their official documents from 3 gender options. So this is going to be for a state-issued ID, birth certificates, and driver's licenses. It's going to give people the right to choose whether to identify as female, male, or non-binary. So these rules are rolling out at the end of 2018, starting in September, and out from there. But it's going to make it easier for people to choose their identification from now on, which is going to make it a lot easier for a lot of people in California. The next one doesn't really change anything for how employers are going to be doing work, but it's good to know that the FEHA law we mentioned earlier, the Fair Employment and Housing Act, they went through it and deleted all gender-specific pronouns and all of the anti-discrimination and harassment and pregnancy and family medical leave policies. So before I would say he or she, and now it just says the person or the employee. It might not affect you directly, but it could affect how the laws are interpreted and which laws apply to different people. So, and I think it's just a important symbol of how California is treating this harassment and discrimination stuff. So just good for all employers to know. And the last one here is about the Fair Pay Act. Also, this probably doesn't apply to most of you on this call, but this is the law that prohibited wage discrimination on the basis of gender, race, and ethnicity. It used to only cover private employers, and now it also covers public employers too. All right, onward. So here's a little bit more discrimination and harassment changes. Also probably these won't affect you. They're pretty niche, but I wanted to mention them in case we do have any companies that apply to these very specific laws. So the first one applies to farm labor contractors. Basically, only if you're applying for a farm labor contractor's license, there's now this extra harassment prevention training required. The next one is about data collection on sexual orientation information. The state labor agencies already are constantly kind of getting voluntary information from people about, race and gender and things like that. Now they're also expanding that information to collect voluntary self-identifying information about sexual orientation and gender identity in the course of collecting all the other information as well. So that's going to let the state get a lot more accurate demographic data, and I presume will kind of feed into continuing refining these laws based on the information they get, which I think is a pretty positive thing. If you run a long-term care facility, there's now a new Residents' Bill of Rights that applies specific to the LGBT community. There's now a notice requirement and a lot of record-keeping requirements. You now have to use residents' preferred names, preferred pronouns, and you can't deny somebody admission to the long-term care facility because of their gender, based on their gender or sexual orientation. So that's also an important one that's going to protect a lot of people. The next one, there are new requirements for human trafficking notices. So if you own a hotel or a motel or a bed and breakfast, it's now required that you post notices about human trafficking to, reach out to people in case that that they're in a position where they're being trafficked, to give them an opportunity to try and get help. So not only are these notices now required in hotels, motels, and B&Bs, but the notices also have to include a number that's available for text messaging if somebody is not able to actually make a phone call. So that's pretty great. That actually doesn't apply until January 1st, 2019. But if it does apply to you, make sure you have this because it's up to $500 to $1,000 per penalty, per offense, excuse me, if you accidentally violate this one. The next one applies to veterans. It's just an expansion of current protections, which prohibits discrimination in all terms, conditions, or privileges of employment. So again, we're just trying to do a little extra to protect veteran discrimination here in employment. And finally, there's a new whistleblower provision that applies just to healthcare facilities. To protect whistleblowers here. So the fines for violating the protections of whistleblowers in healthcare facilities went up, or apply now. They're between $20,000 and $75,000. So if you're in the healthcare industry, be careful there as well. All right, so still no questions. We're going to keep going. There is a big one, again, I haven't heard anybody talking about, but I think it's pretty scary. The Labor Commissioner can now investigate all California employers about potential retaliation against employees without a complaint by an employee. So it used to be that the Labor Commissioner could only investigate a potential retaliation claim if an employee complained that they were retaliated against. So retaliation is one of the biggest and fastest growing lawsuits that happens by employees to employers. This is when somebody claims that they have been punished in some way, including firing, but even just simple things like having their desk moved or something like that, because they brought, discrimination or harassment or a violation to the company's attention. This is very illegal, and it, again, can happen by accident all the time. So what this means is, before, they can only look into a retaliation claim if somebody explicitly complained. But now, if the commissioner is already looking at your company for some reason for a wage claim, or they're doing an inspection, or they're looking into potential, immigration threats, or any sort of investigation they're already doing, they can now look into whether you have there's been potential retaliation, whether somebody's complained about it or not. So this makes me a little bit worried for employers. I'm worried that the Labor Commissioner is going to, kind of take this to an extreme and go after people a little willy-nilly, and so it's a little concerning to me as somebody who works with employers. But the point of it, of course, is to encourage, to minimize retaliation and not have people be just too scared to come forward with a retaliation claim. Still make sure that it's not happening. So the other thing they're allowed to do now is get a court order that prohibits you from firing or disciplining an employee before the investigation's even finished, or before they even find that retaliation has happened. So the way that this could possibly play out is, they do an inspection in your office, or they're doing an investigation for a wage claim, and then they can start an investigation about a retaliation claim because, you just fired somebody, and the commissioner thinks that you fired them because of retaliation, but really you just fired them for something totally different. Before they even find retaliation, it can be a 2 or 3 year long process where they're investigating the claim and figuring out whether whether retaliation has happened, where you can't fire this person. They can prohibit you from firing them or from disciplining them, even if they haven't found that there was actual retaliation that happened while the investigation is still going. So I'm hoping that they don't abuse this new power, but it's I think that there's potential for abuse there. So we have to be really, really extra careful now as employers to make sure that our hiring processes are really good, that our firing processes are really solid, that if anybody is being reprimanded or disciplined in any way, we have really thorough policies in place, hopefully in a handbook, and hopefully we're actually doing all of the things that our handbook says, make sure we're following our procedures, that our handbooks are up to date, that our policies are reflecting the law. Just, we need to make sure that everything is solid, because that's going to really be the thing that's going to protect us here. So the labor commissioner can't just come in and prevent us from firing somebody we want to fire for 3 years because they think that there might have been retaliation. So we'll see how this plays out again in court. The other part of this is that they reduce the burden of proof to get this injunction. They made it a lot easier to force you to not fire somebody or force you to not discipline somebody. So hopefully we have all our stuff up to date, and we'll protect ourselves that way, but we'll see how this plays out. There is a penalty of up to $20,000 for non-compliance with court orders. So, if they try and do an injunction and you ignore it or things like that, it's just going to be very, very, very expensive. So I wanted to make sure all of you knew about that one, because I think it's a pretty big one. All right, we just have a couple more slides here of a lot more of these little ones. So again, these ones kind of might not apply to you, but I want to put them out there and make sure you know they exist if they do. So the first one is about cleaning products. This is a workplace safety law. So this one says that manufacturers of cleaning products and chemicals have to disclose the chemicals that are in there and make these safety data sheets that describe, how safe these chemicals are. And then any employer that uses these cleaning products has to get those safety data sheets and make them available to their employees. So this is really going to apply to companies that provide, janitorial services or house cleaning services or things like dry cleaners, maybe. Anybody who's using these kind of industrial cleaning products on a regular basis, just to make sure that workers are aware of the risks and know what chemicals they're working with, so they have the ability to choose not to work there, or at least take safety precautions if they need to. So let's see. Oh yeah, and the next one is just, there's a little more clarification in the law about when owners and officers and board members can exclude themselves from workers' comp insurance. So if you are a business owner, and I'm assuming some of you on the call are, you may or may not, you might be able to exclude yourself from workers' comp coverage if you want. Most owners do, because they don't want to have to pay the extra workers' comp fees, and you're not going to sue yourself for workers' comp, presumably. So, so just take a look and see if that's something that applies to you. So another few small ones here. There have been increases in both paid family leave and state disability earnings. So this may not affect you directly because you're taking all of those payments out of workers' paychecks, but employees in particular would be interested to know. Paid family leave increased from 55% of earnings. You can now get 60 or 70% depending on your income, and there is a maximum. And they got rid of the paid family leave 7-day waiting period to be eligible. So that's going to help out a lot of people who go out on paid family leave. State disability, same thing, same increase. You can get it up to 52 weeks. There's still the 7-day waiting period for that. The next one may apply if you own a bar or a restaurant or anybody who serves alcohol. Come 2021, there's going to be a certification required for anybody to serve alcohol. They're going to have to get a license. So there's going to be mandatory training on alcohol responsibility, and presumably some sort of test or class that they need to do and get certification. So the Department of Alcoholic Beverage Control is creating that certification right now, but that's going to be a requirement in 2021. So if you have or plan to have a business that serves alcohol, just a heads up that that's rolling out in a few years. The next one applies to construction contracts. It is probably mostly bad news for the general contractors. It puts more liability onto the general contractor for any unpaid wages or benefits that a subcontractor owes to their laborer under a contract. So kind of just puts more of the responsibility up the chain, so make sure your contracts are really good and solid, and you're hiring good subcontractors and have good contracts with them if you're a general contractor. The next one is applies to barbering and cosmetology workers. That just allows them, first of all, to get a commission in addition to a base hourly rate under certain conditions, but it also, they added a lot of for the health and safety courses that they have to take. They're now including courses on physical and sexual assault awareness, which is great and will hopefully protect some people in that industry. All right, and the last ones here, hopefully this one doesn't come up for anybody, but employers now must provide a nurse case manager to advocate for an employee if the employee is injured by an act of domestic terrorism. This applies when the governor declares a state of emergency, and the Workers' Comp Board is going to develop regulations on the scope and required notice here, but just a heads up that that's rolling out. And again, hopefully nobody ever has to use that. The next one here is about liens provided to medical providers. So it just extends the automatic stay on liens filed by medical providers who are charged with criminal fraud. So I don't know if there are any medical providers on this call, but if it is, this applies to you. Hopefully you won't be charged with criminal fraud, but just know that this exists. And finally, there's just an extension of a billing deadline for people who provide emergency treatment services. You can now bill up to 180 days and not just 30 days. So those are the new laws, but what can we do as a business owner to protect ourselves from these changes and make sure that we are complying with all of these constantly changing new laws? What we like to do in my law firm is prevent problems instead of fix them. We can fix them if we need to, but it's a lot easier to prevent a problem than to fix a problem later. So all of these laws that we talked about, some of them, first of all, you can just get penalties directly from the government for, and sometimes those penalties can be in the thousands or tens of thousands, and also lawsuits. Most of these you can be directly sued by an employee for a violation of a lot of these laws. And the stat is almost 50% of employers in California get sued by their employees at some point. So at my law firm, we consider it more a matter of time, a matter of when than if. It's really important to protect yourself in advance and make sure to try and avoid these as much as possible instead of having to solve it later. Because even if you were, tried your hardest, it can get very, very expensive. Even if you win, it's still going to be tens of thousands of dollars to protect yourself and hire a lawyer. So one thing that my firm does is provide employment audits. And so an employment audit is really just, we go into your company, we have you send us, all of your documents, and we ask you a bunch of questions and make sure that your posters are all up to date. Their hiring processes are up to date. We look at your harassment and discrimination policies, and we just kind of analyze everything, let you know what we think might be opening you up to potential liability, so you can decide what you want to do about it and see if there's something you can do to help protect yourself and your company in the future. We also offer an employment package, which just does all of those things for you. So we'll give you your posters, we'll give you your handbook, we'll write all your policies and procedures for you, and make sure you understand all of these laws to make sure you're complying with everything, and all of your supervisors are complying with everything to make sure you're protected going forward. It's also important, like I said, it's the law if you have 50 or more employees to do the harassment training, but we also do recommend doing it even if you don't have 50, even if you have fewer. Our law firm provides that, but we usually just recommend you can get them online for much, much cheaper. And there's pretty good ones out there that you could just have everybody do online for, I think it's usually $25 to maybe $40 per person. So that's a good way to make sure everybody in your company is educated about the laws in California. So, again, we see these employment laws as just kind of a minefield for potential liability and lawsuits, and they're very complicated. And we much prefer to work with people to prevent the problem from happening in the first place. Let's see. So, regardless of who you work with, we do recommend just getting a team that you trust. If you're outsourcing your HR, you're doing it internally, or, get a good HR team, get a good lawyer you can ask questions to, make sure you have a good CPA you can ask questions to, make sure you have good insurance that covers you if something does go wrong. So I'm still not seeing any questions. I'm going to keep going here. That wraps up most of the main changes I wanted to go over today. We do have, this was our first webinar actually, but we are going to be putting them on usually around once a month. So if you want more information about those, our website, ahuronewbusinesslaw.com/events is always going to have that information. And you can also follow us on Facebook. We blast them on Facebook every time. So we're just at Ahu New Business Law on Facebook. I also wanted to mention, if you're in the San Francisco Bay Area, in Oakland on February 24th, it's a Saturday, we're having a day-long in-person event. It's about everything you need to know to start your own business. And so we're going to cover everything from what licenses you need, how to pick the right business entity, all the way through the basics of employment law and trademarks and intellectual property, kind of start to finish, step by step, everything you need to know. So let's see. Okay, I did get a question asking more about the construction or contractor law. So I'm just going to go back really quick and explain that one. So the way that one is going to work is, okay, so let's say, usually the way that it works is the general contractor kind of in charge of the whole contract, and they're usually allowed to subcontract with, more specific specialists, like they'll contract the plumber, they'll contract the roofer or whatever. In this case, let me find it. Where'd it go? If there are unpaid wages or benefits or contributions that a subcontractor working for the subcontractor owes their own laborer, then the general contractor at the top can be liable now for the wages that the subcontractor owes his or her laborer. So it increases the potential liability. It puts the responsibility more on the general contractor and not just on the subcontractor. So I hope that explained it. If you want more of a more detailed explanation about that, feel free to email me or talk to us individually later. Yeah, let us know if that applies to you, and we can. Okay, and so yeah, this is our contact information. We are recording this, so assuming the recording turned out okay, we'll make it available to all of you if you want the recording, and we can also send the copies of the slides to any of you if you'd like. So we are going to follow up with all of you over email just to, check in and see if you want the slides and see if you want to be put on the newsletter. The newsletter is the other way that we're going to, spread the word about upcoming events. But if you want to know about that or anything else having to do with your business or any of the stuff we talked about, this is our contact information. And I think that's it. So unless I have other questions that come in right now, I'm not seeing any. So thank you all for attending, and feel free to be in touch anytime with any questions that you might have. And we really appreciate you being here. So thanks everybody again. And yeah, have a great rest of your day. All right. Bye.